Good evening and welcome to the King's College Anatomy Lecture Theatre. And it really is the Anatomy Lecture Theatre. We were just being told bodies would be cut up in the room next door and then projected on this central dais. We're not going to be cutting up bodies tonight, but we will be talking about Inhuman Rights. Is the Sun right about the Human Rights Act? My name is Martin Moore. I'm the director of the Media Standards Trust. We've just recently moved into King's and we're based in King's. We are an independent think tank at King's, and we're working closely with the King's Policy Institute to run this and other events, and hopefully this will be the first of a series of events about the media and public policy, looking at issues like human rights, but also at criminal justice policy, at devolution, at development policy, and other things. We're extremely grateful to Baroness Helena Kennedy for agreeing to give this extremely timely talk tonight. We're on the penultimate eve of the European elections, and this is an unusual European election, given that there has been more coverage of the election than at almost any other previous European election in the last 20 years, not necessarily for positive European reasons. But for those who don't know Baroness Kennedy, I'll just very quickly, and it is very quickly, summarize a remarkable biography, which I can't hope to capture in 2 minutes. But she has, for those who don't know, spent her career championing the powerless. As a QC at Doughty Chambers, she's acted in some of the most prominent legal trials of the last 30 years, including the Brighton bombing, the Guildford 4 appeal, and following the bombing of the Israeli embassy. She's acted for mothers wrongly accused of murdering their babies and campaigned for people's right to jury trial, as well as many other causes. Astonishingly, given that we're in a university, she's also been awarded over 30 honorary doctorates. Particularly relevant to tonight's talk, she played a key role, amongst a few other people, in persuading Labour to incorporate the European Convention on Human Rights into UK law. She's also the Chair of Justice and the Principal of Mansfield College, Oxford University. After the talk, which will last about 40 to 45 minutes, there'll be an opportunity for questions, and after that there is a reception downstairs in the chapters. For those who don't know King's well, it's in the second floor, so if you go back to the lifts down to the second floor, or there are stairs beyond the lift, and there'll be people to direct you down there. I will, during questions, if it's all right, take questions from one side and then from the other, because we're slightly restricted in our audio capacity because we only have one mic. So I will start on one side and move to the other. But I will try and take as many questions as possible. And so with that, may I please ask you to welcome our speaker, Baroness Helena Kennedy QC. Thank you.
Well, thank you very much, Martin. That was very kind and generous of you in your introduction. Well, we, of course, are entering the year before a general election, never mind the weeks before the European and local elections. And the political parties are now polishing up their own individual iconic issues and looking for the kind of clear blue water between themselves and their opponents. And one of the issues, which will undoubtedly appear in election manifestos, is going to be the Human Rights Act. It's become a sort of polarised war zone. While the Liberal Democrats and Labour will commit to defending the Human Rights Act and the UK's link to the European Court of Human Rights, the Conservatives will again promise to abolish the Human Rights Act and probably undertake to create a new British Bill of Rights. In the modern world, it would be impossible to be seen to abandon human rights altogether. But the big push will be for the Conservatives to disengage from the European Court in some way, either a total breakaway or at the very least the creation of some sort of arm's length relationship which allows the UK to ignore the Court's rulings which they don't like. They will not win many friends in Europe by doing this. And Mr. Putin will happily, of course, endorse and emulate such a shift, as he doesn't much like the European Court's rulings either. So it's going to be quite a serious issue, and one that we should make a point of knowing more about. What is it with human rights Why should a set of values which seem so clearly protective of our humanity and which speak to our better selves as citizens of the world be so controversial? The ideas around human rights are submerged in the deep well springs of our human needs, and our histories tell the stories for us. We know that what it is to suffer pain and degradation at the hands of another. All of us can imagine that. All of us can put ourselves into those places. We know equally that to perpetrate the torture and pain is diminishing of ourselves as humans. We know the need for tolerance of the other, and we know that it's essential to the working of our communities and that we need to prevent discrimination. We know that one of the most basic human desires is to love and be loved, and for that to be made real, that there have to be protections of privacy and our intimacy and our family life. We know that there can only ever be justice if there are fair and open legal processes, and that freedom of expression is fundamental to the good society. We know that complex systems of government can let people down, and we need ways of bringing challenges. So we know all that. I sit on the Parliamentary Joint Committee on Human Rights, and last Wednesday, Baroness Honora O'Neill, distinguished Cambridge philosopher, chair of the Equality and Human Rights Commission, and appointed indeed by this government, appeared before us to give evidence. And I asked her about press misreporting of human rights decisions, and whether she or her commission ever corrected crass distortions. And she was taken aback, and she said she would quail at the idea of taking on the press. She described it as a Sisyphean task for all of us to explain that human rights are for everybody, and not just the disreputable, as she discreetly put it. Now, of course, there are those who are ill-informed. They are hostile to the European Economic Union, and they either hate anything European or confuse the European Court of Justice, whose jurisdiction largely deals with the commercial, trading and employment issues emanating from the Economic Union, with the European Court of Human Rights. They don't understand that it's a totally separate court. They don't know that the latter court was a distinct creation, brought into being in 1950 with the backing of Churchill, and whose drafting was the product of ingenious work by a number of leading British Conservative lawyers, including David Maxwell Fyfe, the Conservative Attorney General. And of course, it was a direct response to the horrors that had taken place in Europe not that long before, the Holocaust of 6 million Jews and the death and persecution of other minorities. And it, of course, is important that we should remember the legal context as well as the horrors of what had gone before. It came into being soon after the Nuremberg trials, and in fact David Maxwell Fyfe had been present at those trials. And they had highlighted the problems of lawyers and judges being able, as the German lawyers and judges did, being able to claim that they were simply following the laws passed by the German parliament, the Reichstag. The convention creators were picking up the challenge of the Universal Declaration of Human Rights to make human rights a reality within domestic legal systems. You'll remember that Eleanor Roosevelt, the great story of the creation of the Universal Declaration of Human Rights, back from her first meetings in her apartment in Washington Square in February 1947, and how she brought lawyers and judges from all over the world, from every tradition, from the Soviet Union, from China, from the Middle East, and all over. And they looked at what should be the values that could be shared by everyone, that were universal, and that should create a template of values against which all systems of law could be tested. And out of that came the Universal Declaration, a treaty which people signed up to, 53 initial signatories. But of course, how did you translate that into law? And the way that it had to be done was by having law that somehow became national, fed into national systems. And so the purpose of the European Convention of Human Rights was to create norms that were to reach beyond nationhood and national parliaments, and which set a high bar for legal systems of all kinds. And it was a template, that Universal Declaration, as I've said, that all legal systems could follow. And it required independent judges and would mean that nobody could defend complicity in abuse by saying that they were only doing what Parliament required of them. There was some other test in addition to the laws that were passed by Parliament. Now, the European Convention was the first instrument to give binding force to a number of the rights that have been contained in the Universal Declaration. It was the first treaty to establish a supranational court in the world to ensure that states fulfilled their undertakings, and it allowed any individual who believes his or her rights under the Convention have been violated to bring a case. So they're brought by individuals, and if you were to go, as I have done, to the court in Strasbourg and go to the post room, what you see are piles of letters from all over Europe, you know, from Eastern Europe and so on, all of which need to be translated and so forth to get to what it is that the individual is seeking to draw the court's attention to. So what it does mean is that it was the first opportunity for an individual to have a role in an international arena. Traditionally, only states had such a role in international law. So as a result, the Convention was a complete game changer. It was a singular moment in the development of international law, and the British were largely its authors. However, instead of seeing it as a visionary achievement of ours, it produces crazed responses. Wild-eyed opponents froth at the mouth when the court is mentioned. For some, there is almost patriotic mania at the very idea that there should be the sacrifice of any national sovereignty. Yet that was precisely what was signed up to. A small loss of some sovereignty so that a higher ideal might be achieved. And that higher ideal was international standards of human rights and justice. And as globalization has developed in the years since, and in my lifetime, the need for international legal regimes has become the more imperative and not less. The idea was to pull people together into a commitment to high ideals and to international law. Now, the treaty started off with 12 signatory nations, all members of the newly created Council of Europe. But of course now the membership is much, much wider, greater than the membership of the European Union, much, much greater. At present, because of the ending of the Cold War, it is 47 countries who are signatories. And one of the main challenges is to raise human rights standards across a wide swathe of Europe, including Russia, Moldova, Hungary, where the rule of law is fragile and rights are often abused. And you can understand it very, very well if you have been a judge or lawyers in a place like the Soviet Union, where you really had to be mindful of the bidding of the state, where you could not be independent without there being dire consequences, then suddenly to be relieved of that does not change your mindset. And many judges still feel that they are required to find in favor of the state and never, certainly, to criticize state abuse. So, in fact, what we were creating at that time were international standards on human rights, and we recognized that it wasn't just about securing justice. And when Bill Clinton, in the early 90s, encouraged Russia and other places to join the Council of Europe and NATO, it was all, of course, for pragmatic reasons. Essential to trade and investment, because the rule of law and the protection of rights creates greater stability and reduces financial risk. Britain's role is seminal in maintaining the international commitment to those values. And it was about, if we want to do business and we want to be trading, then we have to make sure that people are living up to these standards too. So there were those who were looking at it from that point of view, never mind the business of actually safeguarding human rights and safeguarding values. The values, of course, are meaningless if there are not institutions to make them real. And that's why the court is so important. And it's also why, of course, the European Commission of Human Rights is important, that when the court makes judgments, that then the Commission comes into play, seeking to give assistance and prodding to countries as to how they might give effect to rulings. And we've seen it recently in relation to all manner of things. Russia regularly locking up opponents. We've seen it recently in relation to Hungary, where there was a dismantling of the judiciary because of not liking decisions that had been made by the judges. What's interesting is that the Conservative Party and the parts of the media which are so committed to the idea of the individual shouldn't be extolling the virtue of the European Convention, which is still the only international human rights agreement providing such a high degree of individual protection. Because it's the individual in Russia. It's the family of somebody who is, has been locked up in a mental institution and the key thrown away, who can actually assist somebody in making his personal application to the court. The convention was designed to incorporate a traditional civil liberties approach to securing effective political democracy, recognizing that majoritarian democracy alone was insufficient to make for civilized, just societies. Now, I was recently a member of the commission, a lawyers' fest, that was set up by the coalition government to consider the creation of a British Bill of Rights. Now, it became clear from the very first meeting that even the word British might be contentious in parts of these isles. So we settled for calling it a UK Bill of Rights. Anyway, some of the Conservative members of the Commission, there were 8 of us, and we were all lawyers. There was seven QCs, in fact, and one judge from the European Court of Justice, a Scotch judge. But some of the members of the Commission showed their hand quite early on as being what the Americans call original intention theorists. Original intention theorists. Original intention theorists belong to the Antonin Scalia School of Law. It's a school of conservative legal opinion because Scalia, of course, is a judge in the American Supreme Court, and he insists on interpreting the United States Constitution as the Founding Fathers intended, in his view. And it's for this reason, that because of that kind of dogged clinging to what is deemed to have been the Founding Fathers' intention, that we have failed to see any real change in the gun laws in the United States, and that gun control seems to be impossible, despite, of course, the regular mowing down of children in schools and so on. And it's for this reason that it took so long for the law to act on civil rights for African Americans and for women. The English originalists think that the European Convention is being taken to places that were never within the contemplation of the drafters. And they're right. Because discrimination against women and homosexuals were all part of life in the 1950s. The death penalty was on the statute books. Most lawyers, I'm glad to say, and judges take the view that the law is a living, breathing organism that has to be capable of adaptation to changes within society. That was how we were able to get the change on, for example, something like marital rape in the early 90s. So why the media vitriol? Well, firstly, we should recognize that it is right-wing media antagonism which feeds anti-European sentiment in any form. And secondly, the Human Rights Act was introduced by Labour, and therefore it has the mark of Cain on it. But in fact, all the Act does is incorporate the European Convention of Human Rights into English law. In Scotland, the Scotland Act does the same thing, and in Northern Ireland there's legislation which does it there too. It was passed in 1998, but even before then, there was a welter of complaint. You're all too young, most of you, to remember this, but there was a welter of complaint in the run-up to this, in sections of the press, that such a move would create a charter for criminals, terrorists, and illegal immigrants. So we haven't got anything too different since. And it's in the nature of human rights that they will rouse deep passions, because they will be invoked by all manner of people, including people who have committed crime, but particularly by people who are scapegoated and subjected to discriminatory practices. Human rights engage with deep-seated hostilities and visceral intolerance. But the way that you deal with criminals is to put them before courts and then have them appropriately sentenced. But I couldn't begin to tell you the number of people who insist to me that there should be less human rights for those who commit crime. There should be less human rights for foreigners. There should be less human rights for lesser beings. The way to deal with intolerance is not to succumb to it. You don't treat people as though they're inhuman. And the fact that people in jail will claim breaches of their human rights does not mean courts will necessarily uphold their claim. In fact, more often than not, the reports in the media are about people claiming their rights have been abused, and the claim is shown the door as soon as it reaches a court hearing. But the reporting often creates the claim as if it were established fact, and most human rights arguments, in fact, before our courts, end up being dismissed. Last week, a Telegraph headline raged against the high number of foreign prisoners who had served their sentences but waited in prison for deportation at the taxpayers' expense, all because they were claiming their Article 8 rights to family life, they said. Well, the people have the right to resist deportation. Once we take away rights to appeal, we undermine our commitment to fair trial and fair due processes. And the reality is that 98% of them will fail in their attempts to resist deportation. In fact, of course, what was pointed out was that the real issue isn't the Human Rights Act, but it is the process failure by the Justice Department to get these cases before courts and have them dealt with promptly so that the system can actually roll on. And part of the problem has been cuts to the system and insufficient courts to hear the arguments, and of course the absence of legal aid for many of the situations we're talking about. One of the fascinating things about this issue is that many of the individual cases that elicit a gut reaction from parts of the press, most notably the Sun, the Daily Mail, the Sunday Mail, the Telegraph, and to a certain extent the Times, tend not to be mentioned at all by the other mainstream news outlets. They just don't get coverage elsewhere. This means that from the public perspective, the only information most people see about human rights are the cases that are covered in the right-wing press. The coverage is almost always framed so as to illustrate the absurdity or injustice of the Human Rights Act, with claims that men in prison have demanded their human right to pornography, and illegal immigrants have evaded deportation because they claimed that they had family responsibilities, namely a cat. But even at the less ludicrous end, the reporting is often dodgy. And I wanted just to pick up on some examples. There was Abdul Ishmael. This was reported in the tabloids as a failed deportation of a Somali criminal. You only have to mention Somalia and you're on a curve. The deportation of a Somali criminal because of the Human Rights Act. In fact, he was convicted of actual bodily harm and he served 15 months and was then in detention awaiting deportation. But he was detained for 18 months. And so his lawyers applied to the court and got him bail, but still waiting deportation, but with a tag on his ankle so that he wasn't held for an indeterminate period, adding almost to his sentence. And it transpired that it was the Home Office's delays that were the problem, not the Human Rights Act. But you wouldn't think that from the articles in the Daily Mail, that it would have had you believe that it was all down to European Convention madness. The same sort of situation arises in the case of Mohamed Ibrahim. It was another case that got the anti-HRA spin. This was a case where the tabloids claimed that an alien criminal was invoking the Human Rights Act to stay in the country when he should be deported. The Mail highlighted the case in support of its long-running campaign against the Act in 2010. And David Cameron, in the run-up to the 2010 election, promised he would repeal the Act. He produced an angry outburst about the case, that this should happen, be allowed to happen. We have an Iraqi asylum seeker who killed a child, and there's no way he can be sent back. But on closer examination, the case wasn't quite so straightforward. Aso Mohamed Ibrahim was an Iraqi asylum seeker. And it's right. He ran over a 12-year-old little girl, Amy Houston, in 2003. And I'm afraid she was killed. He was driving without a license and he failed to stop. he had undoubtedly been driving recklessly as his car had mounted the pavement and hit the child. So it was a horrible, horrible case. Strangely, he was only prosecuted with fleeing the scene and driving without a license. There were no charges of murder, manslaughter, or death by dangerous driving forthcoming from the prosecution and the CPS, and they didn't ever explain their decision. He was given the incredibly lenient sentence of only 4 months. I have to tell you that I've wondered, was he someone who was assisting the British state back in 2003 when we were invading Iraq? He obviously had been here as an asylum seeker. Was he someone who was providing information and so on, and therefore got a softer landing than anybody else would have? Or was there special sympathy for him as he had asylum, having fled Saddam Hussein, who was then, of course, our arch enemy, and perhaps that brought down some sympathy? I have no idea. Whatever the reasons, he was dealt with in a very merciful fashion by the prosecuting authorities, and the parents of the little girl were understandably outraged. And so they wanted him to receive a much greater punishment, and they wanted him expelled from the United Kingdom, and they campaigned for 7 long years. And eventually election fever and tabloid campaigning led to the proceedings to have him deported in 2010. But in those 7 intervening years, after he'd served his, albeit short, sentence, he got out, he married a British woman, he had 2 children, he had acquired 2 stepchildren because she had been married before, and he was living a responsible life, hard-working father and husband, and had formed a life here in Britain. Now, Article 8 of the European Convention, I wonder if that was the Daily Mail but in the 7 intervening years, as I've said, he had made a life. And the Article 8 of the European Convention on Human Rights protects the right to family life, as many of you will know. The impact that the expulsion would have had on this family, I mean, particularly, he'd married someone, he'd had children, he'd taken on the responsibility for children of his wife's previous marriage. The court decided not to deport him. The government, they said, had not sought to deport him back in 2003 when he had served his sentence. There had been no application by the government to do that at that time. The government had allowed Ibrahim to stay and acquire a family. The judges found that they had left it too late. Rightly or wrongly, they put the family first. I happen to believe that that was the right thing that a court should do. If the state had not acted in the way that one would have expected back in 2003, and life had taken a different turning and 7 years on, then I think the court was making a reasonable decision. But whether you agree with the court or not, the Telegraph ran the following line: would Harry and Zara, Ibrahim's children, really suffer if a father like this had to depart their lives? It's a facile view. To defend the Human Rights Act is not to defend Ibrahim's appalling crime. But even the families of criminals have rights. And that's what courts have to do, is that they're looking beyond that individual and to the rights and needs of people around the particular applicant. Judges in the immigration courts come under special scrutiny. All of our judges now are jumped on if they make a move that the press doesn't like. But the immigration court judges are attacked vitriolically, regularly, by the right-wing media. The right to family life has been blazoned as a get-out-of-jail-free card. And yet, if you look at the statistics, it's not like that. In fact, the percentage is something like 2 or 3%. As I've said, most cases where the right is invoked to prevent deportation and stay in the UK are lost. Where they succeed is often where the person has lived here since childhood, gone through schooling here, has all his family and friends living here, and has been asked to return to a country where they have no longer got links or know anything about the culture of the place to which the argument goes they should be returned. That, I think, may, in many circumstances, be inhuman. Now, of course, there are abuses of the Human Rights Act, with people trying to invoke spurious rights. But we hear less about the incredible advances there have been in securing justice using the Human Rights Act. You never get that kind of coverage in the right-wing press that I've already mentioned. And yet, the Human Rights Act has brought huge victories for British citizens, preventing local authorities from snooping on law-abiding families, removing innocent people from the DNA database, preventing rapists from personally cross-examining their victims in court. In fact, doing lots of things which have advanced the position of victims in the courts, defending the rights of parents to have a say in the medical treatment of their children, holding local authorities to account where they have failed to protect children from abuse, protecting the anonymity of journalist sources, upholding the rights of elderly couples to be cared for together in care homes, preventing someone from being sacked for wearing a Help the Heroes wristband. I'd have thought the Daily Mail would have loved that. Deciding that the mentally ill also have a right not to be deprived of liberty in the same way as those who are not mentally ill. Greater protection for citizens from random use of terrorism legislation. The famous case of Mubarak, the young man who was taken into custody for a first offence and put in a cell with a well-recognised racist cellmate who killed him. That family would have got nowhere without the Human Rights Act. Now, the press that hates the Human Rights Act never gives it credit when it's the Human Rights Act that has been the legal tool that has secured just outcomes. The case of Beth Warren was covered in some depth by the press this year. Her husband had died of a brain tumour, and he'd long years of treatment, and before radiotherapy, he'd chosen to have his sperm frozen, as he knew that the radiotherapy would leave him infertile. Now, the NFEA, the Fertilisation and Regulatory Authority, said that the sperm would have to be destroyed by 2015, as he had only signed for the sperm to be frozen for 5 years. Well, the man had died, and his wife wanted to complete her grieving before deciding whether she wanted to have his baby. So it was a perfect story for the Mail and the Sun and the Express. And the headlines ran, "Pen pushers won't let me have my dead hubby's baby. Officials want to destroy dead husband's sperm." The headlines were wholly sympathetic to the woman who, in fact, won her case invoking Article 8 of the Human Rights Act, a right to family life. And not one of those papers mentioned the HRA what one, you'd have thought would have been in the headline of the Sun. And then there was the treatment of under 18s in custody. The law was changed thanks to action by a teenager who was held in custody without his parents being told. He was later found not guilty. And when he was successful in challenging the treatment of 17-year-olds as though they were adults, the Mail did not report that it was a result of the Human Rights Act. They covered the issue with sympathy because young people had suffered the consequences of blunt custody rules, but they could not bring themselves to say how victory had been secured. Gary McKinnon's case, another that caused problems for the tabloids. The Daily Mail hailed the blocking of his extradition by Theresa May as a victory for their campaign for common sense on behalf of Gary. A great day for Gary, a great day for British justice. After a 3-year Mail campaign bitterly opposed by America, British courts and civil servants all opposed it. Theresa May yesterday courageously decided Asperger's sufferer Gary McKinnon will not be extradited for hacking Pentagon computers in pursuit of little green men. Well, it's right. The Mail and the Express both refer to Mrs. May invoking human rights grounds, but just couldn't bring themselves to mention the loathed Human Rights Act. Two big issues for the right-wing media where their venom about the European Court has been most evident has been the case of Abu Qatada and the prisoners' voting case. The Mail went to town on Abu Qatada, enraged that someone who had been given asylum in the UK because he faced torture back in Jordan could not be expelled when he became suspected of inciting terrorism. The problem arose because of a decision by the European Court of Human Rights that signatory states were required to protect people from torture. Deportation to a place which has a record of endemic torture would breach our treaty obligations. It didn't matter that the intended deportee was someone like Qatada, who was deemed a national threat. The signatory nation was obliged to deal with the suspect in some other manner. well, the UK devised a rather creative other manner. It brought into existence a new procedure whereby Britain could enter into an agreement with a receiving country that the deportee, a particular deportee, would not be subjected to cruel or inhumane treatment and torture. That could be saved for other people, but they wouldn't do it to the ones that we were sending. So these undertakings, known as diplomatic assurances, were used with Libya, don't sneer now, with Libya and other countries like Egypt. At the hearing in Strasbourg, the UK won the case. Not that you would have thought that by reading the newspapers. Despite powerful legal objections, the European Court accepted the UK's new system of diplomatic assurances as being lawful, and indeed Jordan had agreed not to torture Qatada. The problem that remained was that Jordan said it wished to put Qatada on trial and would not give assurances that the evidence that it intended using against him had been the product of the torture of witnesses. And that was the actual stumbling block. But it would have been hard to draw that information from the coverage by the tabloids. When Jordan eventually succumbed to British entreaties that they wouldn't use testimony, which was the product of torture, Qatada was put on a plane. Nothing much seems to have happened to him, nor to the safety and security of Jordan, but who knows. The other red flag to the tabloids is the prisoner's voting rights judgment. The man who brought the case was a man called Hurst, who has committed terrible crimes, I mean really horrific crimes, and was serving life imprisonment for murders. And the European Court did not decide that Hurst should be allowed to vote, despite the impression you would get from the press. But clearly our Prime Minister thought that that was what the European Court had decided. The decision, he clearly thought, said that rapists and murderers should be able to vote because he said such an idea wouldn't have made him sick. What the court decided was that it was wrong to have a blanket ban. It was the blanket dragnet quality of the ban that the court said was contrary to the convention. Why? Because the convention was brought into being to prevent collective punishments, treating all people as though they were the same. And to fulfill the judgment, all the UK would have to do is decide that the person sentenced, for example, to less than 2 or 3 years should retain their civic entitlement to a postal vote. But most people don't know that. I give talks regularly, and one of the things that comes up is the whole issue of prisoners' voting rights, and people still seem to think that it's going to mean that mass murderers and rapists will all be able to vote, which is absolutely not what the court requires. Yet most people seem to think that it is. For example, Germany has found a resolution to this in that they leave it to the judges to decide on whether to advise. As they sentence, they'll say, and you will lose your voting right because of whatever it is that you've done. And in that way, they retain the individual quality of punishments. Now, these are two classic populist issues, and they're about being punitive. It's somehow not enough to remove liberty and to imprison people. Torture's too good for them. If we think that they might have been up to no good in the terrorism range. We think books are a privilege now, television is a prize that you have to win, and a postal vote would probably mean loads of criminals voting Labour or some other mad party like the Greens, so it must definitely not be available. All I can tell you is that I was in the Old Bailey on the day when Margaret Thatcher resigned. And I have to say that across the political divides in the Baroness there was whooping that Margaret Thatcher was stepping down. Even Conservative lawyers found that something that they thought was timely. Even when you spoke to police officers, who normally are of a Conservative bent, they actually thought it was quite a good thing that she was going. I went down to the cells. The prison officers even were saying, Maggie's gone, my God. I went into the cell to see my client, an armed robber who said, this is a terrible day for British politics. That a fabulous woman like that, she's the only man in the cabinet. And I respect her, he said, and this is a disgrace. So I don't know that people completely understand the political complexion of our jailed population. But the real bug for the media is the tension, of course, between Article 8 and Article 10. Article 8 is the right to family life and privacy, and Article 10 protects freedom of expression and freedom of the press. Over the last decade, the courts have been increasingly prepared to uphold claims by people, usually the famous, that their right to privacy was abused by the publication of information or photographs, and it has driven the press wild. This is the bread and butter of the red tops. Those kinds of photographs, that kind of invasion of privacy is what sells those newspapers. Now, the British press is probably the most vibrant in the world, and always has been, in fact. The spread of the printing press in the 1600s gave rise to the predecessors of contemporary newspapers, pamphlets and broadsides and news sheets and so on. And in 1707, I did a little bit of homework, the first newspaper was published, in fact, by a woman, believe it or not, Elizabeth Mallet, to spare the public half the impertinences which ordinary papers contain. So even then, there was a seeking after something more substantial. But the invention of the newspaper didn't raise the tone at all. In the 1770s, the Morning Post took scandal journalism to a new level under the editorship, in fact, of somebody called the Reverend Henry Bale, who was nicknamed the Fighting Parson. And the Post was full of factually dubious gossip and salacious stories, and in fact, Bate ended up in jail having libelled the Duke of Richmond. So at least bad editors got jailed in those days. Anyway, but his fate didn't deter. And in 1808, a new paper, The Examiner, was launched, and it was also a paper that published the salacious, and so on. And scandal appeared regularly in papers in those days. There was a thing called the Cleves Weekly, which was a police gazette, which was a sort of penny dreadful that was really much like the news of the world today. A lot of it was about the misbehaviour of people of one kind or another. Then there was the Pall Mall Gazette, which ran a whole series of things about behaviour that they disapproved of. And in 1886, the Daily Mail came into existence, with the deliberate aim of being populist and reaching a wide audience. And even then, its coverage was very much in the tone of indignation and disgust, while delighting in the content. 30 years later, in fact, it had got to such a place that in 1926, a law was passed to constrain the reporting of scandals in the popular press, because there was a sense that scandal mongering was out of control. Well, the press took no notice, and there were repeated inquiries into the press. And in fact, since the Second World War, there have been 6 inquiries. 1947, there was the Royal Commission on the Press, which was the Ross Commission, and it led to a report in 1949, and eventually through the creation of the Press Council in 1953 to deal with complaints. In 1961, there was the Shawcross Royal Commission. 1972, the Younger Committee on Privacy. 1974, the Royal Commission under Macgregor. 1990, there was the Calcutt Review, which created a new Press Complaints Commission. And in 1993, a follow-up review, again conducted by Calcutt. So what's new? I really think that freedom of the press, of course, is one of the key elements in any democracy. And you only have to see the logjam of cases before the European Court in that press room that I described to you, in that post room, with all those letters from places, former Soviet countries, to see why it matters. Journalists are regularly jailed, and their human rights don't matter a jot. The reason the issue of press freedom versus privacy has become so hot here, I think, is for 3 reasons. One is that our own privacy has become much more vulnerable, and we've recognised that the issue of privacy is one that will, into the future, be a very potent issue. We've also seen an upsurge in celebrity culture, and the press, of course, is in a state of crisis because people are not buying newspapers anymore, or far fewer, and they need scandal to sell papers. So the shift is brought about by the amazing advances in technology and our pathetic efforts to contain some of the downside that flows from it. Unfortunately, Fleet Street has been standing in the way of finding solutions. Now, I'm a criminal lawyer, and I've been aware throughout my life, my professional life has really shown me that the trade in information between the police and journalists has gone on forever, and it certainly has gone on throughout my whole professional life. In fact, I wrote a television drama series back in the late 80s, and one of the scenes is of money changing hands between the police and a journalist about a case that is being covered. Police officers could always rely on there being what was euphemistically referred to as a drink if they passed on juicy information to the press. There were always buns, there were always drinks, there was always stuff going on which was about passing on information. And they usually, the police would have particular relationships with particular journalists, and they would feed them information at a price. And so how else could the paparazzi know to be outside addresses when arrests were made, or police stations when suspects attended to answer simply questions? Tabloid journalists are some of the main users of unlawfully obtained personal information. And it's taken often from police records in the old days, but nowadays obtained from police computers. And we know that that goes on. And particularly as computers have advanced, the ways in which one can get into them has been shared in particular ways. Police officers retire early. It's a strenuous job, and it usually requires a lot of fitness and shift work, and so many police officers retire around 50 and sometimes even younger. And so what they do is, with their retirement pot, they often set up businesses as private detectives or security consultants. And as private detectives, they maintain their police contacts and bring the techniques learned in policing into their new world. Today, that includes the use of listening devices, phone hacking, the blagging of information from busy people in doctors' surgeries, in hospitals, in local councils, in phone companies, and hard-pressed staff are readily tricked into giving out information to the wrong people. We regularly give away personal information online when enrolling with a GP, or even joining a gym, or registering for internet banking, or buying something. And there are many unscrupulous people who will pass on that information, often for a price. And sometimes they do it for personal reasons. A woman was prosecuted just last year she was working for a bank, and she looked into the account details of the woman her husband had left her for, to see how much the woman earned and to use the information in divorce proceedings. And she was prosecuted successfully under the Data Protection Act. What is needed, of course, is an effective deterrent for the misuse of information. And it's not as though attempts haven't been made. Richard Thomas, the former Information Commissioner, called for a custodial penalty for egregious breaches of the Data Protection Act. The penalty was introduced in the Criminal Justice Act in 2004, not brought into effect. And you have to ask why. It creates sentences of up to 2 years on indictment and up to 6 months on summary conviction in the magistrates' courts, and it just hasn't been brought in. It's hard to know why the change is still not operative. Now, when I was chairing the Human Genetics Commission, which I did during for some 8 years, from 1998 to 2006, and the theft of DNA became an issue. And you will probably remember when President Bill Clinton was here for a G8 meeting in Birmingham, he seized a photo opportunity by having a pint in a local pub. And the piece of information that jumped out at me from a news report was that his secret policeman not only paid for the drink, but also for the glass, wrapping it carefully in a napkin and placing it in a bag. Memories of a stain on a blue dress flooded back to me. Someone was guarding his DNA as well as his body. Around that same time, as you'll remember, there was also a wealthy Californian was named as the father of the child born to Elizabeth Hurley, a revelation made possible because the paparazzi had stolen dental floss from his trash can and had it DNA'd. Hints were even being made in the press about the fathering of Prince Harry. Now, I was concerned as much with ordinary members of the public as I was with the famous. I was concerned about abuse by persons other than private detectives or journalists, because we were receiving evidence before the Commission, the Human Genetics Commission, of relatives doubting the paternity of a child. That doesn't look like my son's child, or busybody aunts or control freak ex-husbands secretly taking hair from the heads of children to prove some point in some domestic disputes. And of course completely destroying the emotional security of children, not going through courts, just doing it and sending it off for private DNA testing. And so I made the recommendation, which in fact government took up, which was to create a special offence of theft of DNA, and it came into law back in 2004. For many in the media, the very business of celebrity means the sacrifice of the right to privacy. They feel that you don't deserve it if you're an actor or a musician or a politician or a television performer or a footballer and so on. You're all fair game and not entitled to the rights enjoyed by anyone else. But there was something, of course, particularly vile about hearing the account of Sienna Miller before Levinson being chased down the street by a baying pack of press hounds so that she was in terror of venturing out. And then how she became estranged from a member of her own family, I think her sister, because she believed that she was the only person that she had confided a secret to. And the matter ended up in the press, and it transpired that it hadn't come from her sister. It had come about via hacking. She hadn't spoken to her sister for something like 2 years. Or to hear the torment of media harassment of the new mother of Hugh Grant's child. I mean, does fame really justify that kind of behaviour in the media? Why should that be in the public interest? But the technique spread beyond celebrities. The police regularly hack the phones of those that they're investigating for crime. And it's a small step from the same technique being used in the scenario I've described of the police officer becoming the private detective having the special relationship with a journalist, and those liaisons, meaning that you've got to be ahead of the game in relation to the other newspaper in covering a big story. And so it came about in the Millie Dowler expose that, of course, Millie Dowler was missing. Was she just off with boyfriend somewhere? Had she just run off after somehow falling out with her family and the family weren't admitting it publicly? Or was she the victim of a mindless killing? They wanted to be first with the story, and they got her number, probably from a friend, blagging it from one of her friends. Her message box was full. The detectives then deleted messages to make space for any other messages that might come through that would give them a lead over other newspapers. The scoop, the great scoop mentality. As a result, the police told Millie's parents that someone had deleted messages, and the family seized the information as a straw of hope that she was still alive. The cruelty of it is unbearable. And if they did it then, just how often have they done it in many other cases that people don't know? We only have a fraction of the truth. With the rise of the internet, fewer people are buying newspapers. Back in 1969, when Rupert Murdoch bought The Sun, he introduced page 3 girls, and he said it was for one reason: it was to increase sales. And since then, the internet has driven sales of papers down. And it's why we're seeing the proliferation of free news sheets. It's also why papers have to be more and more competitive, with a greater urgency than ever before to secure headline stories. And that is what led to a descent into more and more unethical practice. A Scottish friend of mine came down to London to work for one of the big press barons, but after attending a meeting where he heard a risk analysis, can we stand the story up in court? Not really. If they sue, how much will it cost us? Is it worth it in sales revenues and attention that we'll get? Yeah, we'll just run it. Truth played no part in the calculation. He went back to Glasgow to work in education. He couldn't stand the taste. The scoop isn't new. Evelyn Waugh's brilliant book gave us an idea of the lengths to which journalists will go to get one. And I suppose it's like being a trial lawyer. I want to win. However, the ramping up of scoop madness meant ethics went for a Burton. When is public interest about more than what the public might be interested in? Law, like ethics, is really about the black and white. There is almost always a balancing process, an engagement of our judgment. If money or profitability is the only arbiter, then ethics are lost. Naomi Campbell brought a case against the Mirror and eventually won a landmark decision in the House of Lords. She argued, in fact, using English tort of the breach of confidence. But it was supplemented with an argument using Article 8, which protects, of course, the right not to have private information misused, and she won. The precedent, I mean, it went all the way to the Supreme Court, but the precedent put the fear of God into the press, and for a while war was waged against the courts, and particularly against Mr. Justice Eadie, who seemed to corral all the media cases. The case which rode things back was the Max Mosley case, which was against the News of the World after their expose of his penchant for dominatrices. The coverage included allegations of Nazi role-playing, and the paper relied upon secret filming and photography. Max Mosley had been taken completely off guard, and he complained bitterly there was no public interest issue. He applied for an injunction to prevent further publication, but Mr. Justice Eadie decided that the horse had bolted, and that since the material was so widely available across the internet, the courts could not, to use his phrase, slip into the role of King Canute. Max Mosley did not slink away as most people would do, but sued the paper for invasion of privacy. His sexual proclivities had been paraded before the world, and there could be no claim of public interest. The News of the World argued that his right to privacy had to be balanced with the freedom of the press and their right to publish what they claimed was a display of hypocrisy on his part, as he'd always distanced himself from his father, Mosley, who'd been the leader of the Nazi black shirts. Yet there he was, acting out a Nazi fantasy, they said. Max Mosley won his privacy claim on the basis that his private indulgences were shared with the world, and yet there was no hypocrisy. And that was the court's view, that there wasn't any hypocrisy on his part. There was no Nazi element to the sexual role play. He got £60,000, not a fortune by today's standards, and his costs. Mr. Justice Eadie said that he would not grant punitive damages because he didn't want a chilling effect on the press, which needs to be able to pursue investigative journalism in the public interest. Mosley's real complaint was that he had not had a chance to take out an injunction beforehand. He'd had no forewarning. And he argued that there should be pre-publication notice given before such a story. Now, many newspapers do inform or ask for a comment before they publish, but sometimes they don't, as the powerful would prevent publication of things that do need to be aired. I mean, Robert Maxwell was a great, injunctor. He was always getting injunctions. And in fact, we might have had more justice for more people if he hadn't been able to do it. But the case of Max Mosley went all the way to the European Court on that issue, should he have been allowed an injunction to basically, information in advance so that he could have sought an injunction. And the court, in fact, found in favour of the press. You'd have thought the press would have been serenading the European Court of Human Rights. Anyway, the European Court found in the favour of the press, saying that a balance has to be struck between the different convention rights. And they invoked the margin of appreciation, which is a thing where you have to let countries themselves find their own way of interpreting something. And so they invoked the margin of appreciation, saying that the UK had the right to set the balance as they saw fit. Now, many lawyers were critical of the European Court at that time for being cowardly, pusillanimous, and leaving the tabloids free to invade privacy with their checkbooks at the ready. But others urged judicial caution. Joshua Rosenberg was very clear that the judges should take care and draw the law of privacy very narrowly, or they will be subject to sustained and undermined attack from the press. So he was basically saying, not on principle, but basically, if you're seen to be actually drawing this too widely and the press see you judges as your enemy, they'll come after you. And so Joshua issued a sort of warning for the judges that they should take care. And indeed that's what the judges have done, because we have seen a rowing back on the whole business of the European Court and of the Human Rights Act. But Mosley is an example of the sort of case where the damages were probably worth it to the press, because it was such a juicy story. And that's the disgrace, the kind of story that attracts and keeps readers over several weeks. And the truth is that no amount of damages and compensation ever takes away once a story has run. Now, I imagine that after last week's European Court of Justice's case against Google, where you remember there was a right to be forgotten, where someone, Mario Gonzalez, brought a case saying, I want something removed from my history, because otherwise it's unfair. And the judgment in his favour is now being called the right to be forgotten judgment, and I think Max Mosley would have a good application to have that part of his internet history expunged. The right-wing press, and I do feel that this is the right-wing press who are doing this, it's making it their business to rein in the judges. And it's why we've recently seen, so many, we've seen over the last 10 years, incredible attacks on the judiciary. and not enough protection of the judiciary from the political class. And now we're seeing judges fall over themselves to disclaim any allegation of being slaves to the European jurisdiction and jurisprudence, and lining up to criticise the European court's expansionism, as it's been called. Now, the hypocrisy around newspapers taking a stand on the high ground that they're really protecting freedom of the press and free speech is, I think, extraordinary. The annual index on media freedom, which was published on the 1st of May of this year, is published by the Freedom House, which is an NGO that's existed since 1941 and which monitors freedom of the press. And basically, they pointed out that Britain had fallen down by something like 5 places post-Snowden, because the majority of our press were indeed pusillanimous and failed, in fact, to rise to the occasion, and in fact have been very, very willing to control the message at the behest of government with regard to those issues. And so, you know, the proud boast of being committed to free speech and freedom of the press doesn't hold up when examined by international bodies, and we are now down at 36 or something on the list of protectors of freedom of speech. Our globalised world is presenting us with very real challenges. Challenges that cross borders, and I see this every day in my work, whether it's about human trafficking, international terrorism, and basically we have to have collective responses. We're seeing it in relation to climate change, but in relation to all manner of other things too. The role for law needs and will increase. The demand for international courts and tribunals will increase. Big corporates are now recognising that they too are better served by insisting on high standards in the countries with which they trade. When Putin jails Khodorkovsky, a leading businessman, or jails the commercial lawyer Magnitsky, and then it led to his ultimate death in custody, it does not excite people to invest in Russia. Lack of human rights protections create instability and raise trade risks enormously. And the corporate world is now realising this. And increasingly there is a search for globalised standards on all fronts, from financial services to corporate tax, for corporations acts, to employment protections, and to minimum wages around the world. The UK, for all its shortcomings, is a beacon on the rule of law and human rights standards, because we all, as citizens and as lawyers and as judges, hold the system to account and keep those standards true. And it should be a source of pride to us. The poison which is being drip-fed to the public by the right-wing press about human rights is nothing short of a disgrace. And it's a disgrace for us all. We're about to have a carnival of celebration relating to Magna Carta. The Human Rights Act embodies principles of fair treatment and humane behaviour which have been in our law since Magna Carta. The roots of it are there. It's the principles that matter. And if we don't defend our traditional liberties, we will lose them. A free press should be protecting human rights. That is what a free press is really for. Thank you.
Thank you very much indeed. Thank you. I will take Chair's privilege and ask the first question, but if people would like to be either thinking up questions or be ready with their hands, we will have the microphone going around the room. I just wanted to ask, in terms of Britain's exceptionalism, is Britain particularly unusual in Europe, both in terms of the press's animosity towards the Human Rights Act, but also some public animosity towards the Human Rights Act, or are there other countries where it's similar?
Well, I first want to say that it's not all of a piece in Britain. When the Commission was set up by the government, the coalition government, and a number of us were appointed to it, one of the things we did was we travelled to the devolved nations. We went to Northern Ireland, to Wales and to Scotland, and took evidence from, community groups, from NGOs, from the political parties, from Parliament, and so on. And it's very interesting because it's different when you go to other parts of the UK. If you go to Wales, Wales liked the Human Rights Act. In fact, Wales is going further, and in fact has extended the protection of children's rights far beyond anything that's available in England. If you go to Scotland, there isn't the animosity to human rights in Scotland, and in fact, when you ask them, they are quite delighted at the idea that they will have direct recourse to the European Court. So they're not in horror of the European Court, even if you talk to the Scots Nats. So, I mean, you don't have this problem in other parts. You do, of course, have concerns in Northern Ireland, because there are those who feel that human rights are being invoked by the nationalist community to seek protections against some of the long-term abuses that the nationalist community experienced. But also, the victims on the kind of, the unionist side are invoking human rights for lots of reasons. So if you started unpicking it in Northern Ireland, I think you would have problems there too in destabilising a very, I think at the moment, quite fretful peace process. So, I mean, it's not all of a peace in the UK, but where it is all of a peace seems to be in England more than anywhere else. And I think that's because of a particular hold of particular tabloid newspapers and particular press. I also think, I mean, you just don't get this in other parts of Europe. If you talk about in Germany, they're aghast that there's a possibility that Britain might try to pull out of the European Court of Human Rights. I mean, they are absolutely aghast. So I find it, but of course, when I made the little aside about Putin would be perfectly happy, Putin doesn't like it. He wants to be part of the Council of Europe, but at the same time, he does lots of bad things. And if he thought that you could have what conservatives describe as being a democratic override, something that said, we in Britain, our parliament is going to vote on this, and we decide that we don't like your judgment, European Court, and so we're just going to ignore it, but we're going to do it by having a debate in Parliament and deciding we don't like it. Well, the other places in Europe will decide to do the same thing, and Putin would delight in doing such a thing, and would be very easily able to get a parliamentary majority, even if you put it at a high level, to say we should be able to lock up critics of the state or journalists who write articles that we don't like. So I really do think we have to be very cautious about what's involved here. But it's interesting because, you see, I see us as being part of a fabric that goes beyond these islands, that we're all working together to try and raise human rights standards, not just in Europe, but also around the world, and that we have an important role to play in that. Once Britain is seen as actually somehow seeking to limit its engagement with this stuff, I think it sends a very, very negative message to the world. And it depends on whether you're an internationalist or a little Englander, whether you think it matters.
Thank you. I'm going to take two or possibly three questions at a time. So if I could take a question here and a question there and a question up there. And then we'll move to this side second.
Thank you. In a very comprehensive talk, you addressed, I think, all sides of the argument, except the side of the argument that I held when I arrived. So I'm waiting eagerly to find out why I'm wrong to hold the view that I do. And it's this. When you acknowledge the original intention theory, I think you acknowledge that the interpretation of the convention has moved on from the way it was when it was written. So there's no point in citing the fact that Churchill and other conservative lawyers were the originators of the convention, because conservative...
You do to some people who just don't know that piece of history, but it certainly doesn't, it doesn't explain where we've got to, because, of course, we have moved along
Yes.
the way.
So it seems to me the issue is, does the court or is the convention being interpreted in a way that would now attract our support to cause us to enter into it if we weren't already members? Or to put it another way, it seems to me what's lacking and what causes all the criticism is it's the absence of a mechanism which ensures that the convention is continuing to be interpreted in a way that would cause the signatories to want to remain in it. And that, I think, is the problem.
Thank you. We're going to take another question here. Question up there.
Just a very short question. Would you see a linkage between, and if which linkage between the opposition against the Human Rights Act and the opposition, or you could say hatred, against the European Union?
Okay. Thank you very much. And one further question just there.
Another short question. Was the work of the Commission on the Bill of Rights given much coverage in the press, and how were its findings reported?
So we have a question about the interpretation and how it's changed, a question about the European Union ECHR, and a question about the Bill of Rights and the coverage of the Bill of Rights. Commission, sorry.
It's an interesting question, that. Would we join the European Convention on Human Rights today, given the jurisprudence that has emanated from the court in the interim, if we were sort of a nation coming to it anew? And you'd have to put that in the context of our politics at the moment. I think that if you had said that back in the late 1990s, would a Labour government at that point have done it? I think so. I think there was a lot of interest and concern about the treatment of homosexuals and the desire by gay people to be treated in a fair way so that their relationships would have the same value as the value of other relationships. I think there was a lot of interest by women's organisations and women concerned with equality and ways in which the human rights protections could be invoked by women. Particularly, I've invoked them regularly for women in cases involving sexual violence and domestic violence and things like that. So I think that there was a rise of feeling that there were ways in which our law had a deficit and that we might have been able to use this productively. But one of the things was that it was about challenging, already there was a use of the European Convention of Human Rights, even although we hadn't brought it into English law, it was being used by lawyers in the courts prior to 1998 and the Human Rights Act being passed. And the courts were increasingly willing to listen to arguments invoking the European Convention on Human Rights. So our judges themselves were hearing these arguments, but then having to often make decisions that were falling short of what would have happened in Europe. So I think there was a swell of feeling by the late 1990s that would have said we would have signed in. Would we now? Well, I think that, and then it was to this question of by our second questioner, which is that I think that the whole business of Europe has been infected by anti-Europeanism. And the demise of the euro, the crisis around the euro, and a sort of rise around immigration, all of that has fed into anti-Europeanism, anti-immigration, and the kind of protections that are invoked by and are possible now using the convention. So I think that at the moment, no, I don't think that people would be probably signing up to it as it currently is. But I'm damn glad that it's there, because I think that a lot of people will be dealt with very unjustly if it weren't. And I say that as a lawyer practicing in the courts, where I see a lot of pain and suffering by people. So I mean, I see it as a commitment to something bigger, and it's important. Do I like all the decisions of the European Court? No. Do I like all the decisions made by our own courts? No. The nature of courts is that they're going to disappoint some people some of the time. But I don't see them as being as frightening and awful as many people do. And it's interesting, you say that you came with a position which was, which you didn't feel I had countered, which was that we've gone too far, that it's sort of gone too far. And I'm always interested to know, what is it that you think has happened that's too far? Where has it gone too far? And that would involve a dialogue that perhaps...
Yes, let's one of the drinks afterwards. And the question about the Commission on Bill of Rights, what was it covered? I mean,
was it covered? Well, it was interesting. You see, the Commission was a coalition effort to deal with that split where Conservative position is to abolish the Human Rights Act, and that was in the last manifesto. And the Liberal Democrats' position is very supportive of the Human Rights Act. So there was a real, down in the darkness, kind of disagreement around the Human Rights Act. And so they needed a way of trying to resolve that. The question was, would a British Bill of Rights that everybody could agree to find a solution to this? But the problem about it was that what the Conservatives on the Commission wanted, they wanted human rights minus. They don't want the European Convention. They want less than the European Convention. And most people feel that the only things that are missing are protections for things like jury trial, or the protections that we saw weren't readily there around having habeas corpus really written into law, because of course we had to go all the way through these processes when we locked people up in Belmarsh, because we thought they were enemy aliens, after 9/11. So I mean, there are things that people would like to see in there, and for example, Wales would like to see something in there which was more about children's rights and protections for children, and so people could add things, but what the Conservatives on the Commission wanted was less. So when the report came out, it was 6-2. I was in a minority report with Philippe Sands, the international lawyer, and we wrote a report which said that we were unhappy because we realised that it was about pulling out of the European Court of Human Rights, and that was what 4 of the commissioners who were for a British Bill of Rights really wanted. They want a British Bill of Rights only because they want it to be less rights, and they want a hierarchy of rights so that there'll be rights for full-on, complete British people, and less rights for Europeans, and even less rights for people from further afield. And that's not in the nature of human rights. Human rights are about humans.
And how was that? How was the report covered? Was the report covered?
It was welcome that the majority were in favour of a British Bill of Rights, but there was very little about the detail, and certainly very little about the fact that 2 of us felt very strongly that it was a Trojan horse for something really much less good in terms of the protection that most of us want.
I'm going to take some questions from this side. So I have a question here. We'll take one question from there and then one question from back there. That's right.
If the stories were true about human rights, I'd probably be against it myself. But the problem is that most of the newspapers are writing nonsense about human rights. If it was true that someone could stay here just because they had a pet cat, Ken Clarke spoke out against that, and soon afterwards he lost his job as Justice Secretary. If it was true what they wrote about Abu Qatada, I asked people whether they'd be prepared to be extradited or deported and face torture. They wouldn't be, but they seem to think that human rights should only apply to certain humans. So my question is, how are we going to redress the balance? How are we going to actually answer the misinformation that has rubbished human rights in this country? Because if not, it's not just the media. The Conservative Party has pledged to actually abolish the Human Rights Act and end up with a Bill of Rights which will be completely watered down and not the same.
Thank you. Can we take a couple more? Can you decide which?
Could we both ask 2 short questions to combine one long question? I was just going to ask, you talked mainly positively about the effects of the Human Rights Act, but many academics argue that in fact it didn't have a lot of constitutional consequences. Like up the top of my head, I'm thinking like 2 cases, A, the UK, where even though there was a significant human right violation, the House of Lords just did a declaration of incompatibility, and there was another case, Gillian, for example, where the House of Lords said the stop and search powers were reasonable, and the ECHR disagreed. So do you think that, in fact, the Human Rights Act did achieve significant consequences?
Sorry,
So, is there a strong case to be made that the European Court of Human Rights isn't actually robust enough mechanism for protecting human rights abuses? And the key case I'd put before there is the case of Baba Ahmed and others, in which case the European Court of Human Rights legitimised indefinite pre-trial solitary confinement, which you see your client Mehdi Hashiin, the prison regime where 50% of suicides take place in United States prisons, and life without parole and indefinite solitary confinement, which the United Nations Special Rapporteur wishes to abolish. My particular interest in this is my brother was a person with the Asperger syndrome and assessed suicide risk who is now in indefinite solitary confinement, and that was given a green light to by the European Court of Human Rights, one of the few judgments which David Cameron was pleased about.
Thank you very much. One more question up there, because we're running out of time, so if we could take a question from the man in the checked shirt up there. Thank you very much for passing the microphone.
So what's your view on the recent decision by Phil Shiner to use the European Court of Human Rights to sort of continue his case against the British Armed Forces actions in Iraq, particularly what was the al-Suwaidi inquiry?
Okay. So, should we start there and then come to how we address the balance? Because that seems to sort of bring everything together at the end.
Let me take the two your questions together. To my friends there, is there a constitutional tension around when our courts might decide something and then it goes to, let's look at the business of stop and search, right? Our Supreme Court decided an application was made, with human rights arguments invoked. Our Supreme Court said they thought it was not a breach of human rights. Goes to the European Court, the European Court finds it in the other direction. I think that all the evidence now has pressed the Home Secretary, Theresa May herself, to actually revisit the whole issue of stop and search. And in fact, the Court and Human Rights Commission led, I promise you, at the moment, Honora O'Neill is no wild-eyed, human rights uncritical person, and she would be very clear that it had got out of control, the extent to which there was stop and search of particular communities. So I think that, yes, of course there are going to be niggles and bits of tension. No nation likes it when the European Court decides that, your court's got it wrong or we disagree with you and send back that judgment. And we're no different from any other country when that happens. But if you're part of a community, a legal community, trying to raise standards, then sometimes you have to take it in the neck and swallow it. And that's what happens as a lawyer. It happens to you as somebody bringing a case. So, sometimes things go your way and sometimes they don't. And we as nations have to stop this business of stamping our feet and forgetting that the purposes of this are for some greater ideal. And every so often we will, with kind of wanting, in the vast majority of cases, not that many cases from the UK actually go to the European Court, and of those that do, very few of them involve in the end a judgment against the UK. Very few indeed. And you'd think it was happening every day in the week, and it just isn't true. As my friend whose brother is in custody in the United States, and the fact that the European Court failed to find in his favour or to criticise the British court, that's my answer to you over there, is that, you might not think it's the European Court's terrific and wonderful, and you might think it's terrible and it's doing things that are... there are other people who think the European Court is a pusillanimous, cowardly outfit that doesn't do enough on human rights. And so somewhere in there, you win some and you lose some, and that's the nature of courts. And courts disappoint me as much as they disappoint other people when I don't win. But, I really think that the critique of the European Court has been absolutely overblown by the media. My friend up there on, do I think Phil Shiner's right or not? I haven't looked, they're not cases that I thought he made a very, very brave fight on Baha Musa's part. What happened to Baha Musa was disgraceful. And when we fall down on the job, even our armed forces, when we fall down on the job, we should be brought to account. And so, if he feels that there's a case to be brought to the European Court, then quite rightly he should do so. That's what fearless lawyering is about, and that's what we need to have in a country that's free and where we feel that law is a tool for those who have been abused. So I'm absolutely on his side if he thinks there's an argument to be made. We need to make those arguments in the courts. But then, to my friend in the front, what do we do about all of this? You know, the lies feed into people's understanding of the court. You know, the vast amount of the work that's done in the European Court is done relating to places where, you know, which are, you know, quite far from here. The terrible wrongs that are going in other places. For us to pull the carpet out and to sort of say, we're not going to play anymore, we're taking our ball home, it would be such an affront to something that has been working, you know, difficult stuff, and moving forward, sometimes 2 steps forward, 1 step back, and then forward again. This is, the purpose and intent is to create a safer and better world, a world which is humane, a world where there is compassion, a world where there is understanding. Now, that, you know, human beings do bad things. And when they do bad things, they should be punished for doing bad things. But we shouldn't try to find ways to how to make the punishment even more exquisite and ghastly. And we shouldn't be saying that, that they are no longer human and therefore have sacrificed their rights to protections under human rights law. But that's unfortunately the thing that many people feel. You committed a crime, you should have your human rights taken away. You've been hanging out with people who've got bad politics, your human rights are of less value. And I'm afraid that that's not in the nature of human rights, because once you start making and picking and choosing who's worthy of protection, then we fail our own humanity. And so when you say to me, what can we do? We have to just keep making the case and making the argument, and we have to keep reminding people of the good stuff, and we have to try and persuade some of the newspapers that just don't cover this stuff at all, or very little, to make the argument for why, you know, when the cases are won invoking the Human Rights Act, which are cases which are about, you know, elderly people in care homes and their treatment, you know, things that concern us all, and especially as one's getting older, then I'm telling you that we should be talking about how the Human Rights Act, as Honora O'Neill said, is for all of us. And we would soon know if we were in trouble ourselves, if we weren't in a position to be able to invoke them. So we just have to keep making the case.
It is a very warm night. It is after 8 o'clock. We have a reception downstairs, so please do come and join us downstairs. But before you do, please could you